Hello, and welcome to HETP's Connected Communities Digital Forum. My name is Alejandro Roark, and I'm the Executive Director for Hispanic Technology and Telecommunications Partnership. HETP is a CEO roundtable of 16 of the country's oldest and largest Latino civil rights organizations who work in coalition to promote access, adoption, and the full utilization of technology and telecommunications resources by the Latino community across the United States. Through our community engagement, congressional education, and by serving as a national voice for Latinos in tech and telecom policy, HETP member organizations work to support the social, political, and economic advancement of over 50 million Americans of Latino descent by facilitating access to high-quality education, economic opportunity, and effective healthcare through the use of technology tools and resources. This virtual briefing series is dedicated to exploring the intersection of ethics, technology, and public policy by engaging scholars, community thought leaders, civil rights leaders, and policymakers from diverse backgrounds to give greater context to the lived reality of Black and Brown communities in our increasingly digital world. Today's special edition of our Connected Communities Digital Forum is presented in partnership with DC AI Week. AI Week is the nation's only week-long tech festival dedicated to artificial intelligence and brings together thousands of C-suite leaders from the government, tech, and education communities across the nation with the sole focus of understanding artificial intelligence and its power to revolutionize the world around us. Before we begin today, I want to invite all of our friends who are tuning in live on our website to join the conversation on Twitter by following @HTTP_policy and using the hashtag AI Week. That's hashtag AI Week. Our conversation today explores how risk assessments, technology design, and public policy each have a role to play in the way that AI systems are developed and deployed, and how redefining the way that we consider risk helps to center equity as a distinguishing feature and the outcome of American innovation. We are joined today by Andrea Arias, attorney at the Federal Trade Commission, Division of Privacy and Identity Protection, Mona Sloane, senior research scientist at the NYU Center for Responsible AI, Vinhcent Lee, Technology Equity Legal Counsel for the Greenlining Institute, and Bertram Lee, Counsel for Media and Tech at the Leadership Conference for Civil and Human Rights. So thank you all very much for being here with us today. Mona, I would love to start with you because we have all kind of heard about the mysterious black box that powers AI algorithms and that gives machine sight. So as senior research scientist at the NYU Center for Responsible AI, and as a sociologist working on inequality in the context of AI design and policy, do you mind taking us inside of the black box and kind of sharing with us your perspective on how predictive analytics make decisions?
Yes, of course, Alejandro. And thank you so much for the invitation. And I'm so honored to be on this panel with Vinhcent, Andy, and Bertram. And I can't wait to delve into the conversation. So as a sociologist, what I really do is I look at what makes society tick. So when we talk about having a candid dialogue about artificial intelligence, I want to start with a question, which is, what does that have to do with how we organize society at this point in time? And I think the most important observation is here that AI truly has become integral to the way in which we stratify and organize society, recreate hierarchies, and organize our social lives. Now, to wrap our heads around how and why that is, I want to offer two observations for this conversation today. The first is, and this really is somewhat of an old chestnut at this point, is that we should be a bit clearer about what AI means. And this is actually a very current, relevant policy question, which I'm sure my co-panelists agree with. There are many takes on what AI is, but let's focus on predictive analytics specifically for the sake of this conversation. Now, predictive analytics are technical systems that analyze data in order to make a prediction that serves as the basis for making a decision. That decision can be made autonomously or with a human in the loop. For example, predicting what the next word in a sentence will be as you type into your phone, and based on that decision, suggesting what the next word could be. We call this autocorrect. This is a matter of calculating the probability of an event occurring. In other words, we are dealing with statistics or math when we talk about AI as predictive analytics. What is important to remember is that as we deploy the systems as part of organizing society, we're seeing a bigger and bigger impact. These systems are deployed in the context of loan decisions, college admission decisions, benefit decisions, so in the public sector, if you get a job, if you're released on bail, and many more. So the stakes have become really much higher than just autocorrect. There is actual algorithmic harm that can occur, and this harm is distributed unequally across society, much more affecting communities who are already being discriminated against. There are plenty of examples at this point. For example, we see algorithms, or we have seen algorithms or AI dictating that less resources be distributed to sicker Black patients than healthier White patients in the context of the healthcare sector. We've seen that buying bulk food being classified as abnormal shopping behavior, causing the loss of benefits. This is in the context of automated fraud detection. We've seen the word women on a CV causing automated hiring tools to send anonymized CVs to the bottom of the barrel, as it were, and more. And as we can see, and this is my second point, there is a significant impact and therefore a significant risk related to these systems, particularly in the context of public agencies using these systems. Now, as public agencies take to AI to rapidly solve issues under conditions of strapped resources, and let's not forget, we're still in the middle of a pandemic, they can actually end up exacerbating these inequities that I just spoke about, even though they are tasked with mitigating them. Unlike private companies whose remit it is to shareholders, or whose responsibility is primarily towards shareholders in the context of profit generation, public entities must consider the entire population when delivering solutions. So the use of AI in the context of the public sector is quite different. The public use of an algorithmic decision-making system has different requirements than a private use product. It is acceptable for a private company to create a product that addresses the needs of, for example, 80% of their target market. However, if this product is translated to public use, addressing the needs of 80% of your constituency is unacceptable. It is also likely that the 20% who are not addressed are likely to be from underserved minority groups, as we just discussed. So this gap is rarely considered. We have seen biases manifest in federal COVID-19 funding allocation algorithms, favoring high-income communities over low-income communities due to historical biases that are baked into the training data. So really, we're seeing this risk tied to the way in which we reimagine and rebuild the economy post the recession. So if we don't want these systems to scale up and exacerbate the inequities in our society, we need guardrails. And I think we're kind of in agreement on that. As regulators on both sides of the Atlantic grapple with that task, and the European Commission has just released their suggested regulation for AI last month, and we can talk about their sort of crown jewel later, which is the classification of so-called high-risk AI systems. I want to sort of throw in 5 points of conversation here, which are all grounded in ongoing research and projects that I'm doing. Number one, I think we need distributed accountability mechanisms. As part of developing those, we need to talk a little bit more about product liability regimes. Second, we need to mandate rigorous AI impact assessments prior to the development of an AI system. That is particularly systems that are used to assess people. Third, similarly, post-deployment, we need socio-technical audits, and I'm happy to talk about what I mean by that holistically assess an AI system beyond just the simple question of whether or not it worked as intended. Fourth, we need innovation in public procurement to establish set accountability mechanisms, to establish impact assessment, to establish audit mechanisms, and also cultures. And I really think we need to invest in capacity building and knowledge sharing for public servants and those who want to have a career in the newly forming space of public interest technology. And I'm going to leave it at that. Thank you so much.
Of course. No, thank you, Mona, for that grounding for our conversation. I think those are all kind of great points for us to think about, and I think a great jumping off point. So, Bertram, I know that you've spent a lot of time thinking through how to advance the interest of historically marginalized communities in tech and media policy. And I know that you have some specific thoughts about the term risk specifically, and its inherent framing or our framing of risk assessments to achieve either corporate or social outcomes. Do you mind sharing a little bit about your work at the Leadership Conference and how we can begin to redefine risk?
Absolutely. And thank you, Alejandro. And thank you to HTTP for hosting a conversation on artificial intelligence and its impact on communities, particularly historically marginalized communities, such as people of color, women, immigrants, LGBTQ individuals, for DCAI Week. I'm Bertram Lee, Policy Counsel at the Leadership Conference on Civil and Human Rights, a coalition of more than 220 national organizations working to build America as good as its ideals. And one of those ideals is to make sure that new technologies further, not hinder, civil rights protections. And I think one of the ways in which to frame AI and its impact on marginalized communities is just to think about how AI currently impacts a number of traditional civil rights issues and traditional spaces, including, but absolutely not limited to, education, Title VI of the Civil Rights Act; employment, Title VII of the Civil Rights Act; credit, the Fair Credit Reporting Act and Equal Credit Opportunity Act; housing, the Fair Housing Act, right? And criminal justice. And there are significant Sixth Amendment issues with the current use of AI within the context of the criminal justice system. And so one of the ways in which that we think about AI is where do we get to compliance, right? And I think that is the issue that I think vexes, many within the civil and human rights community through the idea that how do we get to a point where we know that the AI used in these traditionally protected civil rights classes is compliant with, if not the exact letter, but the spirit of civil rights law? How do we make sure that that's transparent? How do we make sure that companies know their obligations to civil rights law and not hide behind any variety of business reasons to engage in non-compliance, right? I think that's point number one. Point number two is that the Leadership Conference has worked on these issues since 2014. In 2014, the Leadership Conference, along with a number of partner organizations and coalition members, put together the era of big data, civil rights in the era of big data principles. Those principles were updated in 2020. You can find those linked on not only my Twitter, but you can find those on the Leadership Conference page. And a lot of those principles, and the key idea of those principles, is to make sure that technologies work for marginalized communities equally as well as the rest of society, and that these technologies do not discriminate based on protected characteristics, which is a core element of how we've interpreted civil rights law since civil rights law, and really since the 19th century, if you really want to look at the Civil Rights Act that were passed in the wake of the Civil War. And so lastly, I think there are a number of issues that we're concerned about as it pertains to technology and how we think about risk, right? One of the ways in which you can think about risk is, who is it risky towards, right? When you're talking about what the risk is it a risk for the company or is it risk for an individual? And really what we've been talking about in pertains of risk, and I think the larger conversation is missed, is that there have been risk assessment tools for, say, someone who may not pay back a loan, or risk assessment for them to be go back into society and commit another crime or not show up in court. But we don't talk enough about the risk that there is for those people to be put in that system and the risks that they have for not being able to be out. And for instance, on pretrial risk assessments, if you are not allowed to go out and continue to go back to your job while you are still within the context of the criminal legal justice system, that has an economic impact for generations. That impacts not only the individual, but the individual's family and the individual's children and potentially their children's children if they do not find themselves out of the criminal legal justice system and within the proper context. And so we don't think about the risks that these algorithmic technologies have on marginalized communities, and we need to change that. And lastly, I think we need to think about accuracy. And we need to think about bias within the context of how are these things working for the communities that are not only protected by law, but also protected by the context of how they frame what is the protected by the social contract that we have, right? We have a collective contract with one another that society works fairly, right? And America is building America as good as its ideals, right? And so it is hard to change an individual standpoint about not only race or class or kind of getting into kind of the, I would say, the inherent biases that we all come with, right? That's hard to change for an individual. That is much easier to change for a computerized system. And that is something that I think we can hold people to a high standard for. And I think that when we're talking about these contexts, it's important to say that there is a significant human cost, like not only like human cost to individual lives, but taxpayer dollars and even like corporate dollars, right? The less diverse a corporation is, McKinsey put out that study a few years ago, the less money it makes. There's a cost to engaging in this kind of discriminatory algorithmic practices that we're just not talking about. And I think that within the context of risk, it's a risk to everybody to continue engaging in algorithmic practices that are not only biased, but inherently unfair. And I think that's something that we need to think about moving forward.
Absolutely. Thank you so much for that. So Mona, I actually want to go back to you a little bit because Bertram raises a really great point, which is a lot of the way that these automated systems are developed today, they really are focused on understanding or mitigating risk, right? But I think it's important for us to really kind of underscore risky for who, who are they protecting? And what are the kind of processes or social assumptions that inform the development of this technology? And I wonder if you might have some insight into, I think, the current state of play for the development of these technologies.
Ooh, that's a big question. Let me try. So I think what you say there is really important, which is the question, what are the kinds of assumptions that are baked into the technology, which is a different question than asking, is there just bias in the data set that trains these systems? Because when we ask about what kind of assumptions about society and certain communities are baked into the system, we can ask questions around what is the system optimizing for? Who is it optimizing for and in what way? So for example, if you're optimizing for the reduction of fraud in a public benefit system, your model will optimize for that and will try to find as many fraud cases as possible to, of course, which will then, of course, or is likely to cause harm for communities who are already discriminated against. So that's one thing. The other thing is that when we talk about risk and we talk about risk for whom and to whom, then I think when we look to the corporate side, we can say, well, essentially we've got two streams. We've got risk in terms of reputational risk for companies. And we've sort of seen that, for example, in the recent months with Google and the firing of Dr. Tim Gabru and Dr. Meg Mitchell, and sort of that's a reputational risk. And there are significant reputational risks associated with the deployment of these technologies. When it comes out that they are actually discriminating communities, that this is a risk to the corporation. I will say, though, that flagging risk is labor that rests on the shoulders of those who are experiencing the harm, right? Like only when there is harm that occurs and that is flagged by these communities, it becomes, it becomes known as risk to the corporation. The other one is regulation. Corporations on the corporate side understands regulation as a risk. And we've seen that a fair bit happening with the EC having dropped the regulation. And I would love to hear from Andy also, the FTC's thoughts on that. But that's another sort of risk stream that we are seeing. So I think there are all these moving parts. I think we're at a point where we need to really sit down and wrap our head around that. And as Bertram has said, we need to bring folks to the table and define a workable definition. And we need to also develop socio-technical literacy. So we need folks to understand that systems are not just technical systems, but systems that, where technology and society kind of work like this. It's not just one way. And I'm going to leave it at that. I hope this was a sufficient answer.
Yeah. Yes, of course. And I think that's a great segue for Andrea. So, Andrea, we know that the speed of innovation continues to transform our lives at a rapid pace. The Federal Trade Commission, whose charge is to protect consumers, has been working to understand and define consumer harm in our new digital reality. I know that you were one of the key drafters of the FTC's Big Data Report, and I wonder if you could share, what are some of the main consumer protection issues raised by algorithms, and maybe provide some insight into the legal tools that the FTC has at its disposal to curb that consumer harm.
Sure, and hello everyone, and thank you for having me today. It's a pleasure to be here. Before I begin, though, I have to disclose that today's comments are my own and do not represent those of the Commission or any one of its commissioners. All right, with that aside, so I'm really glad that we're here today discussing the impact of AI on multicultural communities, not because I'm glad this is happening when it's harmful and not beneficial, but rather because there are serious issues that require serious attention. So, as you all know, while the sophistication of AI and machine learning technology is new, automated decision-making is not, and we at the FTC have long experience dealing with the challenges presented by the use of data and algorithms to make decisions about consumers. So very briefly, for those of you that do not know, the Federal Trade Commission is a highly effective independent agency with a broad mission. Our mission is to protect consumers and maintain competition in most sectors of the economy. On the consumer protection side, our measures range across a variety of issues, from student debt relief, scams, to various types of false advertising, and many others. But today, we're here to talk about privacy and data security, and in particular, AI. So the FTC has been the primary federal agency charged with protecting consumer privacy since about 1970. Yeah, believe it or not, with the passage of the Fair Credit Reporting Act, as Bertram kind of alluded to earlier. So from the growth of the internet to the mobile device explosion to the arrival of IoT and artificial intelligence, we have continuously expanded our focus on privacy to reflect how consumer data fuels these changes in the marketplace. And so over the years, the FTC has brought many cases alleging violations of the laws we enforce involving AI and automated decision-making, and have investigated numerous companies in this space. For example, the Fair Credit Reporting Act and the Equal Credit Opportunity Act, also known as ECOA, enacted in 1974, both address automated decision-making and financial services companies. And we have been applying these laws to machine-based credit underwriting models for decades, okay? We have also used Section 5 of the FTC Act, which prohibits unfair or deceptive practices to address consumer injury arising from the use of AI and automated decision-making. So I thought it would be helpful for me to kind of give you guys a little bit of an understanding of these laws so that we can understand kind of how they apply in this space. So first, let me take Section 5 of the FTC Act, which prohibits unfair and deceptive practices. How does this work in the AI space? In appropriate circumstances, the Commission could challenge the use of a discriminatory algorithm as either unfair or deceptive, or both. If, for example, a company used an algorithm that generated biased results impacting consumers' access to a service and failed to take reasonable steps to correct that bias, the FTC could use its Section 5 authority to challenge those practices as unfair. Or if a company represented on its website, user interface, privacy policy, or elsewhere that it used an algorithm to achieve fair, unbiased results, when in fact it systematically discriminated by race or other characteristics, the FTC could use its Section 5 authority to challenge those representations as deceptive. Now, the Fair Credit Reporting Act, or FCRA, is also relevant to algorithmic discrimination, where the algorithm affects the content of a consumer report. So the FCRA applies to companies known as consumer reporting agencies, or CRAs, that compile or sell consumer reports, which contain consumer information that is used or expected to be used for credit, employment, insurance, housing, or other similar decisions about consumers' eligibility for certain benefits and transactions. So under the FCRA, and I won't get into too much details, there are several requirements that CRAs and furnishers of information have to implement. So let's say a CRA relied on an algorithm to generate credit reports without maintaining reasonable procedures to ensure maximum possible accuracy of that report. The FTC could challenge that conduct as a violation of the FCRA. And so we have done so, for example, in our most recent case against RealPage in 2018, a company that deployed software tools to match housing applicants to criminal records in real time or near real time. And we allege they violated the FCRA by failing to take reasonable steps to ensure the accuracy of the information they provided to landlords and property managers. Finally, we have ECOA, which is just a small piece of a variety of federal equal opportunity laws, including Title VII of the Civil Rights Act of 1964, the American with Disabilities Act, the Age Discrimination in Employment Act, the Fair Housing Act, the Genetic Information and Non-Discriminatory Act. There's a slew of laws. We at the FTC enforce ECOA, which prohibits credit discrimination on the basis of race, color, religion, national origin, sex, marital status, age, or because a person receives public assistance. So how does that work in the AI space? If, for example, a company made credit decisions based on a consumer's zip codes, resulting in a disparate impact on particular ethnic groups, the FTC could challenge that practice. Or if a lender refused to lend to single persons or offered less favorable terms to them than married persons because an algorithm indicates that single persons are less likely to repay loans than married persons, the FTC could challenge that as disparate treatment. So very briefly, I think Alejandro kind of alluded to this, but to complement our enforcement actions, we also engage in a variety of policy initiatives. So as Alejandro noted, we released in 2016 our report on big data, a tool for inclusion or exclusion, which examined the big data industry and gave companies key advice on how to reduce the opportunity for bias when using AI. And I hope in our conversation we get to talk a little bit more about that today. In 2018, we held a hearing regarding the consumer welfare implications associated with the use of algorithmic tools, artificial intelligence, and predictive analytics. As part of our hearings on competition and consumer protection in the 21st century. And in those hearings, we heard from dozens of participants about the potential benefits, right, from these technologies, which can lead to advances in medicine, education, health, and transportation, but can also lead to significant risks, including algorithmic bias resulting from operators' assumptions in data sets imperfections, right? And then more recently, and I think everyone here has seen more recently, we published two blog posts, one entitled Aiming for Truth, Fairness, and Equity in Your Company's Use of AI in 2021, and then again in 2020, Using Artificial Intelligence and Algorithms to provide guidance to companies on how to effectively use AI without having disparate impact on multicultural communities, and encourage everyone to read all of our reports, and all of our blog posts are free to everyone to just go to ftc.gov and you'll find them there. So just to briefly kind of wrap that up, and I hope we have more conversations about some of the guidance that we have in all these reports and policy initiatives that we've put out. We really do believe the FTC's law enforcement actions, studies, and guidance can offer important lessons about how companies can manage the consumer protection risks of AI and algorithms. So I'm happy to chat more about how the specific guidance and the FTC has given these companies on how to effectively use AI.
Andy, I really, very much appreciate that. And yes, I think that we, at least the panelists that are here with us today, have read that blog post. And definitely, I think we're receptive to it. It's definitely making the rounds. So happy to look back around and kind of talk about some of the specific guidance that you guys offer as a part of that new kind of framework. But I want to kind of go to Vinhcent real fast, because I know that the Vinhcent, over the last decade, algorithms have really replaced, as has been mentioned, decision makers at all levels of all society. Judges, doctors, hiring managers, they're all shifting their responsibilities onto powerful algorithms that promise more data-driven, efficient, more accurate, and even more equitable decision-making. However, we know that today, poorly designed algorithms are also amplifying systemic racism by reproducing patterns of discrimination and biases of the past. So I think my question to you and your work at the Greenlining Institute is there a fix to algorithmic bias? And if so, how can we build, more equitable automated decision-making systems?
Yeah, thank you, Alejandro. And thank you for inviting me and being on here with everyone else. I'll say real quick, I'm Vinhcent, legal counsel with the Greenlining Institute. We were formed to combat the practice of redlining, which is, the illegal practice of denying services to communities of color on the basis of race. or related characteristics. And, one big focus on that is making sure that we don't recreate redlining in algorithmic systems, right? And how that impacts economic opportunity, right? So in banking, housing, healthcare, finance, education, AI is making all these decisions. So, one of the big focuses for us at Greenlining is, building in what we call algorithmic greenlining. So AI is really good at optimizing for, say, profit or finding out who's committing fraud, but they're not really good at optimizing for, shared societal outcomes, right? So how do we limit polarization? How do we help the climate? How do we make sure that the racial wealth gap closes? So, one of the key original goals of this work was to build that into systems, to create the incentives and the societal systems where companies are incentivized to internalize those externalities, right? To think about when they're optimizing their algorithm, how is it impacting society? How can maybe we make 2% less profit, but we, have 10% better outcomes for the communities that we serve. So, that's one of our big goals. And we do that in a lot of different ways, but, we do a lot of legislative work where you can get, better, more state investment, more state dollars if you are directing investments to the communities worst hit by climate change. And, that's an algorithm called CalEnviroScreen that Greenlining helped develop in California, where, it's directed billions of dollars to communities that are worst hit by the impacts of pollution. But in building that system, we made sure we included metrics and data that really captured the worst impacts of redlining in terms of, quantifying, who are we going to give money to, which communities are going to get funding. So that's one solution, right? But that was our original goal of the work that we did at Greenlining, but it's really so much focused on algorithmic bias. And it's dealing with a lot of what, Mona brought up is, how do we make sure that we build in the systems for accountability? How do we make sure there's liability for when you are committing disparate impacts? And another part is, I do think that, the FTC is on the ball, but a lot of other agencies aren't, right? And it's just one agency is not enough to capture all the algorithmic bias, to investigate, to create the culture of compliance that Bertram was talking about. So what we want to do is build capacity at state, local, federal organizations to tackle disparate impact, to require impact assessments if you want any federal money, any public procurement of an AI system. And then eventually what we want to do is to begin to shift what are the legal standards around what is a disparate impact? What is a reasonable business necessity that justifies discrimination and justifies unfair outcomes that we consider unfair outcomes for communities of color.
Absolutely. So Bertram, I'd love to kind of loop you back in because I feel like we're really kind of getting to the question of, how do we ensure that our long, hard-fought and settled civil rights laws are clearly translated and enforced in emerging digital tools? And I wonder if you might have some perspective into how you think we accomplish that.
I mean, it's through the regulatory process, So we have these laws have been on the books for decades, and they've changed and evolved over time, right? For instance, the EEOC 4/5 rule, right, was instituted in the 70s, and that's really the basis of a lot of hiring algorithms right now, right? But I don't necessarily think that rule is, I think, not only equitable, but I don't know whether that rule is correct for the current algorithmic system, or the current algorithmic space that we work in right now. And so I think that, there are open questions about that, for example. To add to that example, housing during the last administration, Housing and Urban Development put out a disparate impact rulemaking that specifically mentioned algorithms, right? Agencies have jurisdiction over these spaces. And so there are a few ways to think about AI regulation. There's many ways to kind of go about this. One way is to think about it as we're regulating all algorithms, right? So I've heard the kind of European model and more of the model of like the FAA model or the medical device model, right? Where it's just you take specific portions of AI, right? and specific use cases, and you look at it within the context of, is this working the way that it says it's going to work, right? So there was, for example, there was a complaint against HireVue saying that HireVue has a technology saying that, there is a engagement where they say that it's, there's a complaint against HireVue, and HireVue says, and technologies claim that if they can see kind of a job applicant's feasibility through its facial recognition system. That's yet to be determined. I don't know where the FTC is on that, and not to call that HireVue, but like there's a complaint against whether the algorithm does what it says it does, and that's an open debate, right? But for the context of HireVue within the FTC and within the regulatory structure, right? There are already laws on the books that say if you have a disparate impact, and we've said disparate impact, but let's define it, right? Disparate impact means that a practice on its face is neutral, but has a disproportionate impact on a protected class. And I think that's something to just keep in mind as we're talking about this, because, this isn't to say that there is intent behind it, but that's not necessary for a disparate impact analysis. The impact is that you have it has a disproportionate impact on protected classes based on the actions that you take, and that there is a less discriminatory means and manner by which to do so. Right. And then it goes back and forth between business necessity, but that's for a different legal debate. Right. But I think that's important to keep in mind, that we have the regulatory tools to do so. But I think something that Vinhcent brought up that's really important is that we have not seen kind of agencies kind of like really, I would say, do a lot to regulate AI in the current context, but also there's a lot of space to do more. Right. And we look forward to working with these agencies in order to buff up kind of their AI, not only expertise, but how to think about AI within the context of civil rights. And this goes from rulemaking across the board, right? Across a litany of different spaces. And then this builds to kind of like the second way to think about regulatory process, which is in every single area, we want different AI regulations, right? So education may look different than it does with housing, which does for employment, which does for the context of the criminal legal justice system, right? Which looks completely different for healthcare. All of those areas have different data sets. All of those areas have different, wouldn't say liabilities, but different contexts of how the law has interpreted what not only disparate impact is, but also what discrimination looks like. Financial services has a different bar than Title VII, right? And and that's the court. That's where the law is, right? But again, how do we get to compliance with where the court has been and how it interprets discrimination? And so I think that's the more reasonable and feasible approach, because these industries and these corporations already have a relationship with these regulators, right? And ultimately, as much as I would like to dictate to the companies what to do with their algorithms and how not to be discriminatory, the reality is that the best way to kind of move forward is to make sure that there's some buy-in, right, with these companies, and make sure that they know that you can actually make more money by not discriminating, which is something that we've all said, but it's very hard to adjust. It's like it's making a right turn in an aircraft carrier for a lot of these corporations, and it's even harder for government, right? And so I think that those contexts are really important to kind of like think about how we engage in that policy making. But, the Leadership Conference has done a lot of work on this. We have principles that we've put out on a number of occasions. We engage in comments and engage in the regulatory process to kind of push these things forward. And there are a number of ways in which to think about these things, and there are a number of ways in which to move forward. But when we're talking about this, we do need regulation. And honestly, the industry is craving regulation, because all it takes is one court case for the whole context of how the industry engages in certain practices for them to absolutely have to just modify their practices. We'd rather work with industry to try and get them to compliance, right? Because this is the current law. It's not a new law that needs to be passed. It's not what we should be doing. It's not what we'd like to have done. It's not some moral kind of like idea of like where fairness comes from. It's the law. How do we get everyone to a place where we are transparent with the laws in which folks need to be compliant with, but also how they're being compliant? And I think the regulatory process is the best way to go forward on that.
And Vinhcent, it looked like you wanted to jump in there. Did you have something to add there?
Yeah, just to Bertram's point, that's what we're trying to do in California. There's legislation that we're working on that would require, anybody trying to sell AI to the government to disclose, whether they've done disparate impact analysis, but the original idea of that bill is to make companies disclose, right? Have we done this test? How likely are we compliant with, all of these laws that already exist? And, California as a state would be able to spend its significant purchasing power on the products that have, been more tested, that have gone through the audits. And, we're trying to create the system now where we, encourage companies to do that. And, that's just the first step. But, what I see as a better way to deal with disparate impact is to have companies disclose that on the front end. Rather than having an FTC investigator go to you and look through all your data, you have an AI system, you can audit it on the front end to say, hey, this is our disparate impact of our system among these protected characteristics. This is our reasonable business necessity that justifies that disparate impact, and just put that out there in the front. And then you can sell that product to any, private entity, government entity, and then, it's there. You've proven it on the front end. So that's where I would like to see us go. But, we're starting small, trying to incentivize companies to even do these impact assessments. And I will say one thing is I was on a call with a lot of companies about this bill and trying to get industry on board. And we had a lot of industry folks come in and say, yeah, we want regulation. But when I said, okay, well, let's do this, they're like, well, if we measure disparate impact, then we're liable for it. And I was like, well, yes, that was the point. So it's, we have some ways to go, but I do think regulation also, is the guideline and is the way to kind of create those business incentives that I was talking about earlier.
Yeah. So Andrea, I'd love to kind of come back to you because, I'm really kind of curious to see from your perspective, how well does the FTC's current enforcement tools address potential bias against race, gender, other protected designations within emerging algorithmic decision-making or targeting tools? And I think as we're coming to the top of the hour, if you could also share some of the guidance that you've recently kind of issued to companies that are developing these technologies.
Yeah, I'm actually going to take your question the other way around because I kind of wanted to jump into what Vinhcent and Bertram were talking about, which is, it sounds we're talking a little bit about a carrot or stick model, right? We're trying to incentivize them by telling them why they should be doing the things that they are, but sometimes we need to kind of use the stick. And I think the blog posts that we recently put out are kind of that stick, right? If the carrots are not working, we're going to tell you, okay, this is the sort of things you should be thinking about, because if you don't, then we're going to use the tools that we have at our disposal now to be able to bring an enforcement action against you, right? So let's talk about some of those recommendations that we've made so that companies can avoid the stick from the FTC, as I kind of said. So we did put out those two blog posts and the 2016 Big Data Report, which I recommend all companies that are looking at this to be really thinking about, because I think it has some good guidance and some kind of minimum standards. I don't want to say that they are the standards of what they should be doing when they're using AI to make some of these kind of decisions that we've discussed. So first is the companies need to start with the right foundation. I think Amona, oh no, I have a 4-year-old and obviously we watch a lot of Moana, so that's on my brain. So Mona, you mentioned pre-deployment, right? I think that's exactly what starting with the right foundation comes to, which is what should companies be doing before some of these things are deployed? And some of that is set out in our 2016 Big Data Report, which is how representative is your data set? You should be asking yourself that. You should be asking, does your data account for a model? Does the model account for biases? Really be testing it on the front end, as Vinhcent mentioned. How accurate are your predictions based on the big data? So this is post-deployment, how Mona mentioned. You need to be testing even after you deployed and be thinking about some of the predictions that are being made by those models. And finally, does your reliance on big data raise ethical or fairness concerns? Again, this is post-deployment. We really be thinking about the effects of some of these uses of AI on a variety of communities. So by asking these questions, as a company, you'll be able to determine if your data sets are maybe missing information from particular populations, kind of those data desert questions. As such, may yield results that are unfair or inequitable to a legally protected group. Second, companies should be watching out for discriminatory outcomes. So how can a company reduce the risk of becoming the example of a business whose well-intentioned algorithm perpetuates racial inequity? It's essential to test those algorithms, both before you use them and periodically after that, to make sure that the algorithms don't discriminate on the basis of race, gender, or a protected class. Third, companies should embrace transparency and independence. I think, Vinhcent, you were mentioning a little bit of this before, but as you develop and you use AI, you should be thinking about ways to embrace transparency and independence. For example, by using transparency frameworks and independent standards, by conducting and publishing the results of independent audits, and by opening your data or source code to outside inspection. We've seen actually in a variety of ways how this has led to finding some of these biases, even when companies themselves have been testing and not finding them themselves. Fourth, companies shouldn't exaggerate what their algorithms can do or whether they deliver fair or unbiased results. Okay, so say an AI developer tells its clients that the product will provide 100% unbiased hiring decisions, but the algorithm was built with data that lacked racial or gender diversity, so that may eventually lead to a deception or discrimination and an FTC law enforcement action under Section 5 of the FTC Act. Fifth, companies should tell the truth about how they use data or face a potential deception action from the FTC. Finally, companies should aim to do more harm than good. Oh my goodness.
I was like, wait a minute.
Yeah. Finally, companies should aim to do more good than harm. So if a company's model causes more harm than good, that is in Section 5, that's what we say, it causes or is likely to cause substantial injury to consumers that is not reasonably avoidable by consumers nor outweighed by countervailing benefits to consumers or to competition. I know it's a mouthful, but basically make sure that you're doing more good than harm, okay? Because otherwise the FTC can challenge your use of that model as unfair. So we were talking about so obviously we have a lot of tools. We have Section 5, we have the FCRA, we have ECOA, and obviously we are committed to vigorous enforcement of the laws in our charge. But these laws may not always apply to the use of biased algorithms in some circumstances. For example, when the company controlling an algorithm is behind the scenes, which it often is, right? Separated from the consumer by a service provider or a relationship, there may be no misleading statement or omission that the commission can challenge using our Section 5 deception authority. Similarly, if a company whose algorithm determines how healthcare resources are allocated, it may not be covered by the FCRA if the algorithm is not used to make eligibility determinations for individual consumers. In addition, even if the FTC Act were to apply, or the FCRA or ECOA, and we were to find an instance of algorithmic bias to be deceptive or unfair or somehow violating the FCRA or ECOA, an enforcement action may not serve to adequately deter companies from engaging in these practices. The FTC Act, for example, does not give us at the Commission the authority to impose civil penalties or issue rules related to privacy or data security. These and other limitations, such as limited jurisdiction, there's just some companies that do not fall within the FTC purview, affect our ability to deter unfair or deceptive practices with respect to privacy and security, which may relate to algorithmic bias. This is why we have urged Congress to enact comprehensive privacy legislation that would give the FTC the ability to seek civil penalties for first-time violations, make rules under the Administrative Procedures Act, and exercise jurisdiction over common carriers and nonprofits. Obviously, we'll continue to enforce the laws that we have, but there are some, I think, gaps where I think legislation and Congress could really do a lot of good rather than harm, just like I mentioned before.
So, Mona, I'd like to come back to you because I know that you've done a lot of thinking specifically about what types of technical policy or regulatory frameworks we need to establish in order to give the people building these systems better tools to achieve more equitable outcomes. Do you have any reactions to some of the efforts at the FTC?
I'm going to keep it a bit more general and just sort of connect to what everybody has said and what Andy just has said as well, and sort of add on to the not mountain, but not insignificant list of things we should do is kind of expand our view a little bit when we talk about audits specifically. So audits as a way to, or can be a tool to post-deployment continually manage risk and harms. And as part of an audit and as part of, what I've previously introduced a socio-technical audit, I think we need to find ways to ask questions again about the assumptions that are baked into these technologies, which includes asking questions whether or not we actually want improved accuracies for certain technologies. Do we actually want to improve accuracy for technologies that are deployed against communities of color, for example? Do we actually want to improve technologies that we know are based on eugenicist theories? And I'm going to give you an example. I'm going to sort of stay with hiring tool example. So if we include, or if, no, let's put it that way. If we preclude questioning underlying assumptions and politics of any given technology, then we sort of open up really a space for anything to happen. And we open up a space for companies to actually set their own standards in terms of what an audit means. So there is, as I said, a very well-known, well-documented, and well-criticized history of physiognomy. And this history shows that bodily features and abilities bear no significance on either personality or ability, let alone future job performance. Science that claims otherwise is not science. It is essentially eugenicist technologies, which means that technologies built on that assumption not only perpetuate, but also scale eugenicist thought and practice. This is a different issue than asking whether or not your data set is biased or whether or not, your algorithm works as intended. And this is really where we run into these kinds of questions, which leads me to the second point, which again, is literacy. How can we bring this together? How can we bring together claims or sort of calls for regulators, policymakers, decision makers to be more technically literate with the need to be more socio-technical literate? Where do these technologies come from? What do they mean? And also bring that literacy to the people who create technologies. I'm a professor at an engineering school. I'm a social scientist who teaches engineers, and I can tell you the future generation of engineers really is hungry for that literacy. They are waiting in the wings to do things differently and better. And we have to really get our act together and create pathways and educational opportunities and jobs to make that happen.
Absolutely. Thanks, Mona. And so I think that, we're kind of reaching the top of the hour, and I want to just kind of end the conversation with this question, right? So in your opinion, and this is to everyone on the panel as kind of like our closing remarks, what is our time horizon to set up and implement these new inclusive AI frameworks, right? Before we've reached the point of no return. So before we have gotten to a place where there are more systems creating harm than there are creating good or readdressing that harm. And Vinhcent, I'm happy to kick it off with you.
Yeah, I will say, there's that Chinese proverb, right? The best time to plant a tree was 20 years ago. The second best time is now. So I definitely feel like we could have started 10 years ago. We could have been where the EU is now. We're starting from a little bit behind, but so I think it's already happening. These harms are already happening. So I'm not going to say it's there's a time horizon to prevent that, because it is already happening. But I do think I'd want to see a lot of movement in the next 2 years to start establishing a comprehensive, whether it's at the FTC or another agency, a comprehensive privacy regulator, and getting all of the other accessory agencies that each have their own, housing, employment, healthcare, really empowered to do this work, to get the funding to do this work, and to get the, to hire the right people to do this work.
What about you, Bertram? Any closing remarks?
I think I agree with Vinhcent. The best time, we should have done this. We could have done this 20 years ago easily. But the second best time is now. But I think the point of no return is going to be, I think, in 5 years. Even within the past decade, if you look at kind of the paper that framed the Cambridge Analytica report with Michael Kaczynski, the level of accuracy that companies had about what I would say the personal characteristics of marginalized communities was at 95% back in 2010. I can only imagine what that statistic is now, and I can only imagine what is going to be possible 5 years from now. We're competing against the exponential growth of the technology industry, and of algorithmic intelligence, right, and of artificial intelligence, I should say. And so I think that if we do not do something soon, I think it is going to put marginalized communities even potentially further behind than they already are. And so I think, again, the best time to engage in this conversation is yesterday.
Thank you. Andy, Mona, closing thoughts?
I'm not sure I can comment on a time horizon. I unfortunately left my crystal ball somewhere in the garage. So sorry about that, guys. But I think I can comment on the fact that the FTC has been paying attention closely in the past, and we are looking closely now. And we're ready to provide guidance when appropriate, but also to put our enforcement tools, whatever they may be, whether they're the existing tools or maybe new tools that we develop in the future, to use when appropriate. But we are certainly, we take our mission very seriously to protect consumers in light of changing technology, and we'll continue to do so.
Thank you so much. Mona?
Yes, I'm just going to second all of that and say, yes, the time was yesterday. And I'm going to add to that I really think the time now is for harmonization, for a dialogue with other countries, with the European Commission, and sort of really create a space in which these global technologies are discussed on a global level. And that's one thing. And the other thing, just want to really underline, we're dealing with an incredibly powerful industry here. And that's one to reckon with. And I think if we don't look at it that way as well, where do these algorithms come from? Who do they generate profit for? And at what scale, we're kind of not going to see the whole picture. And we might need Andy's crystal ball.
Well, thank you all again for a great conversation. Unfortunately, we are out of time, but I encourage our audience to please follow Andrea, Mona, Bertram, Vinhcent, all on their social media. I'll make sure to put their information in the video description below. And please also make sure to follow HGTP on our social channels at HGTP_policy to be the first to hear about our upcoming conversations presented as a part of our Connected Communities Digital Forum. So until then, please continue to tune into the conversation, speak out, and stay connected because the future needs our help. So until next time, have a good one.